Hello, welcome back to my channel. My name is Joanne. I'm the learner lawyer. So if you're new to my channel, welcome. If you are one of my regulars or one of my subscribers or one of my members, thank you and welcome back. So today I saw all over my feeds, social media feeds today, that 7M has filed some more stuff. So I was working on a defamation assignment myself, so I thought I will leave it. I haven't looked at anything yet, so we're going to look at it now. I've done this just as a recorded video, just for the fun of it. So we've got, this is the 7M file. We've got 1, 2, 3, 4, 5. 5 documents here. 1, 2, 3, 4, 5. So we're going to go through them all. So there's a whole pile of stuff here. So we thought we might start with, that's a huge affidavit there. That's 67 pages. So one of the things that the court had said that they needed to do was to amend the scheduling order. If they wanted to if they wanted to do discovery and they wanted to do it late, they had to put in a motion. So this isn't a motion. Memorandum of law in support of amended scheduling order. So this is, as I said, this is 7M versus Katie Joy, aka Without Crystal Ball. Memorandum in law in support of plaintiff's amended scheduling order. Plaintiffs in this action seek an amended scheduling order based on the procedural posture of this case. The anticipated discovery required of both parties and the plaintiff's inability to obtain a motion date prior to the issuance of the court order on defendant's motion to dismiss. In its order dated the 13th of July 2022, docket number 16, the court issued a scheduling order with a deadline of August 5, 2022. Mediation to be completed by January 25, 2022. A pre-trial conference on March 27, 2022. And a 3-day jury trial to begin on April 18, 2022. I think those dates are wrong. I think they should be 2023 because that makes no mistakes. So they're saying that, so I think that's an error. It should be 2023. Pre-trial conference, March 27, 2023, and the 3-day jury trial to begin on April 18, 2023. That's just an error. At the time this scheduling order was issued, there was an outstanding motion to dismiss. Defendants had not yet served in answer in the matter. The parties had not signed a discovery plan, and neither party had served its initial disclosures on the other. Item H of the scheduling order stated that this order may be amended only at a scheduling conference requested by either party within 10 days of notice of this order. Plaintiffs attempted to contact the district court multiple times via email and phone between July 13, 2022 and August 5, 2022 to request a scheduling conference. See Affidavit Exhibits J to L. None of its phone requests or email requests were returned by the court. On August 8, 2022, plaintiffs filed correspondence with the district court requesting an amended scheduling order, docket number 19. On the 15th of August, defendants filed opposing the plaintiff's request, docket number 20. On August 17, 2022, the Honourable Curry Willis served notice to both parties, absent stipulation, and request to extend deadlines to this court must be done via motion. Plaintiffs attempted to contact the court to schedule a phone conference pursuant to the scheduling order, but were unable to get hold of a member of the court staff. Following this, plaintiffs followed the court's instruction and made this motion. So they're actually laying out that they've been trying to do what they're supposed to do, but they haven't been able to. Defendants have not served an answer or Rule 26 disclosures upon plaintiffs. Plaintiffs do not yet know what issues will require discovery, nor do have a list of individuals outside of Defendant Paulson who may have discoverable information as to the subject matter of this litigation. As such, plaintiffs respectfully request the court issue an amended scheduling order granting at least 90 days after defendants served their answer and Rule 26 disclosure for plaintiffs to complete discovery. Plaintiffs also request extension of the mediation, pre-trial, and trial dates listed in this scheduling order. Plaintiffs do not anticipate a 3-day trial will suffice for this lawsuit. The 4 plaintiffs have set forth a fact-heavy complaint and requested a jury trial against defendants. As defendants have not yet to serve their Rule 26 disclosure or answer the lawsuit, plaintiffs are unaware of all the witnesses required in this matter. Nonetheless, plaintiffs anticipate at least calling 8 witnesses in this matter. This is without any additional witnesses which may be discovered after defendants serve their answer and initial disclosures. Given the fact-heavy nature of this lawsuit, the number of potential witnesses, and the fact this will be a trial by jury, plaintiffs respectfully request at least 10 days for the trial. Plaintiffs respectfully request an amended scheduling order reflecting the following changes. Defendant's answer due September 9th, 2022. Discovery completion date December 30, 2022. Pre-trial conference June 15, 2023. And after trial, a trial date after July 15, 2023. Now, there's a few interesting points in that. So it's interesting how there's been this big thing about discovery, but because there's been no answer filed, you don't know what you're going to need for discovery because you don't know what the answer is. So KJ's little song and dance actually backfired. Now, they referred to her affidavit here. So let's look at this affidavit. It's 67 pages long, I believe. Let's find it here. So this is her affidavit. So they've got here, so Exhibit A is the copy of the plaintiff's amended summons and complaint. Exhibit B is a true, correct copy of the process server's affidavit. C is a copy of comments by post by defendant Paulson on August 23, 2022. D is a social media post by Katie Joy on or around August 23, 2022. E is a social media post from Katie Joy on the 23rd of August 2022. F is a social media post from August 23. They've gone and got all her latest ones. A G is a social media post around the 8th of August 23. H is a social media post, August 23. I, social media post. J of an email from Alexi Adrian to Amber. K is an email from Alexi Adrian. L is another email. M is a true copy of Saturday and night, which was heard before the Minnesota District Court of Hennepin County, 4th Judicial District. N, case of Ludgate versus Affordable Granite. So these are some of the cases they're relying on. O is a copy of another case. Exhibit P is a true of Katie Joy's social media post regarding court documents dated the 19th, 24th, and May 11th. And Q is a social media post in which defendant Katie Joy expresses, "Let's go, discovery is about to get real," via emoji. So let's have a look. So, as I said, they've referred to that in that affidavit. So they're probably, throughout all of these documents, they're going to refer to this. So this is the complaint that we've read. Okay. And remember, they've put on here all the stuff here. They listed it all: the date, the allegation, or what was said. So the imputation, and then the evidence, because it's a social media post. So again, you've got date, the imputation. Imputation is just another word for allegation. Okay, so then you've got what they've said here. the defamation per se. So this is our claim. Yeah. Okay, remember they had that one. Multiple talent agents have told me clippers are cutting 7M. I've spoken to multiple. Last week, I contacted my colleague at LA Clippers to share information about this discovery and asked them to look into it further and possibly separate with the Crump team, including all the guys led by Daniel. Good news, they were cancelled for their performances. So that's when she was celebrating about that. The emotional intention of the deceptive trade practices, the fact they won a jury trial. So that was the 7th of July. So this is Exhibit B. That's the process server to say that yeah, that he did that. So this is Exhibit C. 4 of the dancers previously had. So remember, this is from August. 4 of the dancers that previously had their management listed of 7M have changed their bios to new managers or now representing themselves. In the past weeks, Aubrey Fisher, Kylie Douglas, Concrete, and Gordon Watkins have removed 7M as their management company from their Instagram bios. All 4 previously were rep by the group. In a recent vlog from last week on Isaiah Shin's YouTube channel, the 7M group went to Universal Studios. The once huge crew is no longer. Kylie, Concrete, Gordon, Aubrey, and Alexandra were not in attendance for the event. Gordon's wife, Alexandra, still has her management listed as 7am. Some is going on. It appears a group of dancers are out. Kylie Douglas said on Instagram Live last night she's not part of 7M any longer. Comments? Let me be way clear. This is a completely false narrative, says Gordon Watkins. Without a crystal ball, Gordon Watkins, okay, so this is my opinion. If you'd like to clear this up, I'm all ears. Gordon Watkins, without a crystal ball, it's been cleared up. I just said it. Without a crystal ball, Gordon Watkins. Okay, but which part? Did I get it wrong that you left? The dance stuff is just my opinion based on what I see. Concrete wrote, Cap. Without a crystal ball, Concrete. Whoa, did you just unblock me? Concrete. Yeah, just to say, Cap, don't start beat. That's not true in your page. Other accounts have enjoyed ridiculing, mocking, and bullying dancers in this story. I am not, and I will not be affiliated with any accounts claiming to be part of this story that have done this. Too many pages have created unnecessary drama. My team is behind the scenes. We care about this story. On IG, I'm solo, period. I'm back to reporting on 7M and will continue. I have worked with the team since day one and I'll continue to share what I learned, but I won't be partnering with any other pages on Instagram. I have a team behind the scenes. On IG, I'm not affiliated with anyone, period. I do not co-sign bullying. Then she says, update. A judicial determination in the lawsuit filed against WICB by Robert Shin, Miranda Derrick, and James Derrick has not gone in their favour. According to a scheduling order filed in court on July 18, 2022, all discovery requests were due to the opposing party by August 5, 2022. WICB, through our attorneys, timely served discovery requests on the plaintiffs on August 5, 2022. The plaintiff did not serve WICB any discovery request by the deadline. On August 8, 2022, a letter sent to the court by 7M's attorney requested an extension of time for discovery. This letter was not served to WICB until August 12, 2022, a week after the deadline. A judge determined that no extension for delays can be granted without a motion for delay. No such motion was ever filed by 7M. WICB disputed their request for a delay because the delay was requested after the deadline. Since April 2022, the plaintiffs have made no attempt for discovery to try and prove their case against WICB. With an extension of time, the plaintiffs will not be allowed to seek any discovery from WICB for their case. A judge is still yet to rule on our motion to dismiss for failure to state a claim, among other reasons. The order is due by the end of August. Most interesting, many people have reached out to WICB to share that several of the dancers no longer have 7M listed as their company. Could some of the dancers be leaving the group? And then Shin and 7M miss discovery deadline. Then they've got this one under new management. That's G. This is H. This is all her recent stuff. Chloe and Daniel Joseph have left Shekinah Church and 7M. Chloe is Robert Shin's only daughter. She and Daniel have been married for more than 7 years. And then she's got here. Here's a statement that they've done here. And then they've done, this is exposing 7M. No date, no time or date shown. The mascot and 7M contract. You spoke to Clippers, right? I did. Who did you talk to? The director of entertainment and the VP of HR. The director is a friend of mine. Interesting. Is that Without a Crystal Ball Reddit? They've gone to Without a Crystal Ball Reddit. So then we've got, I left a message. They said they return calls within 3 hours. So it's a paralegal. Court filing. I left a message for you with no response. I understand that voicemail does not always get through to the corresponding person. A scheduling order was issued on July 18, 2022. Dates are conflicting as Judge Michelle Davis has not issued her order on the motion to dismiss. We are requesting an amended scheduling order be issued after Judge Michelle Davis has issued her order on the motion to dismiss. Any inquiries, please contact. So they've emailed the court. There. Now this is a case. I tell you, this isn't. So this is audit of defendant. Okay. So this is a case. Yes, that's a court file. That's from the court terms. So this discusses motion to dismiss parties, defamatory, argues post allegations, summary judgment motions, statute of limitations, injunctions. So that was a denied motion for summary judgment, denied. Okay, interesting. So this is what they would have looked at and would have quoted from. So they've put this in their case file. Whether the judges looked at this case, I don't know. But a lot of the stuff the judges do is they read other cases. So where those summary words were, that's how you find cases. So it's like a big index, and you put in what you're looking for. So this is so here preliminary injunction, temporary restraining order, injunction parties. So often you have you're looking for defamation and injunctions. You would just put in these words. And then a whole pile of cases come up, and you start working your way through the cases. Okay, so then she's got Anna Douglas says there is more to the story. She seems to believe. So they've got this one, and so here they're showing that she's advertising court documents on her social media. That she's actually. So again, this is the Duggars. Again, they're showing. So this is all why they're wanting a game on counterclaims coming your way. This is 7M, so it says 7M, so it says you're being a game on counterclaims coming your way. So that is all of their evidence that they've put forward. So we've got. So this is the motion. So this is the motion to the defendants, their attorneys, Graham and Martin. Please take note, at the time and date to be determined, plaintiff 7M's Inc., Robert Shin, Miranda, Derek James Derek will bring on for hearing before the Honourable Michelle A. Davis, Judge of District Court, its motion for temporary injunctive relief, motion for protective discovery order, and the motion to amend the scheduling order. Plaintiffs hereby and do move the court on the above stated time and place for the following. So you've got the order for injunction relief, an order for protective discovery, and an order to amend the scheduling. Each motion will be based upon the memorandum of law, affidavits, and exhibits filed. Okay, so that's to say we're doing all of that. All right. So now we've got, this is a memorandum for temporary injunction. So we've got an injunction. So they're wanting her to stop talking about them. And this one is for a protective discovery order, is because, they've shown us stuff about the Douglas case. So 7M, and I haven't seen it yet. We're going to have a look. I'm assuming 7M is saying that she just blatantly just broadcasts court stuff all over the place. So therefore, she has no regard for confidentiality, and they want to protect their information. So this is the plaintiff's memorandum of law in support of plaintiff's motion for temporary injunction. Plaintiffs respectfully request that the court grant their motion for temporary injunction, enjoining the defendants from posting any online content about the plaintiff 7M or its associates until this court adjudicates on the merits of the plaintiff's lawsuit. In the alternative, if the court decides the temporary injunction of all posting is inappropriate, plaintiffs respectfully request that the court requires the defendants include with every post she makes about the plaintiffs or their associates that in the picture and blocks of the text relating to plaintiff 7M and associates that she is currently engaged with litigation with plaintiff 7M for defamation. So there they're saying, we don't want her, we're asking the court to stop her from posting, but look, if you're going to say it's okay for her to post, then we will say that we would like her to state that she's currently in litigation for defamation, in a defamation lawsuit with 7M. The case involving the defendant's persistent and malicious harassment of the plaintiffs through multiple social media platforms, including YouTube, TikTok, and Instagram. The defendants have used these platforms to publish countless amounts of false and defamatory statements about the plaintiffs, including accusations of human trafficking, kidnapping, and waterboarding. Furthermore, the defendants have demonstrated a dedication to interfere with plaintiff 7M's contracts and prospective business relations. Despite the current litigation, defendants continue to post false and defamatory statements about the plaintiffs. A temporary injunction is appropriate because in its absence, the plaintiffs will suffer substantial and irreparable harm for which there is no adequate remedy at law. On the other hand, the defendants will suffer little harm from being enjoined from posting about the plaintiffs from the duration of this lawsuit, which is set for trial next year. Furthermore, the factors under Dahlberg, which Minnesota uses to analyse whether injunctive relief is appropriate, weigh heavily in favour of granting the plaintiffs temporary injunction. So here we go. So we've got the statement of facts. So we've got 7M, California, Robert Shin, Miranda and Derek, independent contractors of 7M. Katie Joy is an adult resident of Wright County, internet personality, apparently. WOACB is a Minnesota company, uses various social media accounts. And so YouTube, Facebook, see the affidavit of, so as I said, Exhibit A. Defendant Katie Joy operates her social media accounts to publish sensational material to gain new viewership. Defendants use their following to monetize various social media accounts, Exhibit A. Defendants hold themselves as an established media personality and self-proclaimed internet troll, Exhibit A. Defendant Katie Joy has a history of intentionally, maliciously, and or recklessly publishing false and or misleading information about various peoples and entities, Exhibit A of the affidavit. Defendant Katie Joy has demonstrated a commitment to interfere with 7M's contract and other potential business opportunities, Exhibit I. The defendant's social media attacks against the plaintiff. Defendants have made an immense amount of social media posts regarding the plaintiffs, which contain false and defamatory statements about the plaintiff and their associates. Exhibit A. A small amount of these statements are provided below. Defendants' posts have included accusations of heinous behaviour. Defendants have stated plaintiff 7M engages in human trafficking. Affidavit Exhibit A, page 4 and 11. Defendants have stated that 7M dancers exhibit signs of being trafficked. Exhibit A, page 7. Defendants have stated that plaintiffs Robert Shin and 7M are predatory. Exhibit A, page 5. Defendants have stated that 7M is a cult and plaintiff Robert Shin abuses women. Exhibit A, page 6. Defendants have stated that plaintiff Miranda Derrick was kidnapped by plaintiff. Exhibit A, page 9. Defendants have stated Plaintiff Robert Shin has waterboarded members of his church. Exhibit A, page 10. At least 2 dancers for 7M, whose defendants have commenced about recently, have responded to her social media posts stating the post was false. Exhibit C. In response to these dancers, defendants did not take down the posts and simply stated that they were her opinion. Exhibit C. Defendants Katie Joy's false and defamatory statements have damaged the plaintiff's reputation and standing in the community. The lawsuit. Plaintiff served defendants with a summons of complaint on August 4, 2022, Exhibit B. Plaintiff's complaint included counts of defamation, defamation per se, tortious interference with contract, commercial defamation, intentional infliction of emotional distress, negligence per se under Minnesota Statute 609.765, deceptive trade practices, and intentional interference with prospective advantage and injunctive relief. Commentary on this lawsuit and continued harassment of the plaintiffs. Defendants have made numerous statements about this lawsuit, including that they will continue to report on this lawsuit and the plaintiffs, so exhibits D to F. After a brief pause, defendants have recently restarted their harassment of the plaintiffs, exhibit G. Recent posts have included plaintiff Robert Shin's daughter and son-in-law, exhibit H. Despite ongoing litigation, defendants have stated that she is back to reporting on the 7M story and would not stop, exhibit D. It has come to the attention of the plaintiff's counsel that defendants have recently been offered a Netflix deal and is being actively encouraged to post about 7M to promote the documentary. During this recent wave of harassment, defendants posted a screenshot where she admitted to interfering with plaintiff 7M's contract with the LA Clippers, exhibit I. Argument. The court should grant the plaintiff's motion for temporary injunction. In absence of injunction relief, plaintiffs will suffer irreparable harm for which there is no adequately remedy of law. Furthermore, in Dahlberg, factors weigh heavily in the favour of the plaintiff's motion. Legal standard. Temporary injunctions are governed by the Minnesota Civic Procedure 65.02. The rule states that a temporary injunction may be granted if, by affidavit, deposition testimony, or oral testimony in court, it appears that sufficient grounds exist. In order for a temporary injunction to be granted, the proponent must show that other legal remedies are inadequate and that the injunction is necessary to avoid irreparable harm. So we've got Medtronic Inc. versus Advanced Bionics Corp. The irreparable harm must be established by verified affidavits or pleadings. So that's from Marshall County versus Ingolstadt. Temporary injunctions are meant to preserve the status quo pending adjudication on merits. Metropolitan Sports Facilities versus Minnesota Twins Partnership. Because the applicant is asking the court to preserve the status quo until trial, the applicant must have a valid underlying cause of action to proceed to trial. Smith versus Spritzberger. Okay, so plaintiff will suffer irreparable injury if relief is not granted on which there is no adequate remedy of law. This is really interesting because they're saying she's still going, she's not going to stop. She said she's not going to stop. This is causing us damage. I'm just interested with how this all works out. How she's going to defend this, because she can't deny what she's said because it's all in there. But I mean, I don't know. I would imagine she's going to get a telling off. If I was her lawyer, I'd be giving her a telling off. But anyway, for a court to grant a temporary injunction, the first step is to determine whether the requisite threat is present. The threatened injury must be real and substantial. And not repairable. Independent School District Number 35, Marshall County versus Ingolstadt. Irreparable harm exists when a party has no adequate legal remedy, usually because its injuries could not be fully compensated through an award of money damages. See Miller versus Foley. Minnesota courts have held that a loss of business and consumer goods can constitute irreparable harm. See Overbelt Cobb Insurance Service Co. Inc. versus Bredston. Discussion: an employee who breached a non-compete and stole multiple of his employees for former customers. Also see St. Jude Medical Inc. versus Carter, stating that the risk to customer goodwill was a circumstance where courts can find irreparable harm. Creative Communications Consultant versus Gaylord, holding that there was irreparable harm to a business when there was a loss of clientele and threatened disclosures of confidential information. Furthermore, another Minnesota District Court held that social media posts containing statements which cause business losses can cause irreparable harm and has granted injunctive relief barring such posts. See Ludgate versus Affordable Rantive and Cabinetry at paragraph 6. Also see Dabnan versus Stanton, granting injunction relief that prohibited an individual from making posts on Facebook or GoFundMe. In this case, defendants have uttered numerous false and defamatory statements that have damaged plaintiff 7M's business reputation and economic prospects. The defendants have made it clear that she intends to use her social media posts to put plaintiff 7M out of business. Exhibit D. Defendants have even blatantly boasted about interfering with 7M's contract with the LA Clippers. Exhibit I. Even when confronted with posting material that's false, defendants have refused to take such posts down, instead characterised her false statements as opinions when convenient. See Exhibit C. Overall, the defendants' persistent false and defamatory social media posts have cost the plaintiff 7M numerous contracts and significantly damaged its reputation amongst their professional community. Defendants' social media posts have not only prejudiced the plaintiffs in business, but also in this litigation. Defendants have made multiple false statements regarding this lawsuit, such as the plaintiffs are completely barred from obtaining discovery from defendant WICB when this is not the case, Exhibit E to F. If the defendants continue to make false statements pertaining to this lawsuit, she will restrict the plaintiff's access to a fair trial. If social media posts, especially which contain misstatements about the court rulings, intend to inappropriately influence the litigation, restrict the plaintiff's access to a fair trial, equitable relief is appropriate. See Dabhan and at paragraph 2. Overall, defendant Katie Joy's continuous posting of false and defamatory material has damaged the plaintiff 7M in both its business and in this litigation. It is impossible to quantify the damage that will continue to occur to plaintiff 7M's finances and reputation goodwill in the talent community, and what it would cost to repair the damage caused by the defendants if this temporary injunction is not granted. Therefore, in the absence of the temporary injunction, the plaintiffs will suffer irreparable harm for which there is no adequate remedy of law. All the Dalberg factors under Minnesota law are satisfied. Once the proponent for temporary injunction has shown that there is irreparable harm, the next issue is to conduct a Dalberg analysis. Dalberg analysis applies multiple factors to determine if injunctive relief is important, including 1, the relationship between the parties, 2, the harm suffered to the plaintiff if his request is denied, compared to the harm suffered by the defendant if the restraining order is granted. 3, the likelihood of success on merits, 4, public policy, and 5, the administrative burdens of enforcing the order. See Dalberg Brothers Inc. versus Ford Motor Company. This analysis does not apply. This analysis applies to temporary injunctions. MGM Liquor Warehouse International Inc. versus Forsland. Ekman versus Bruta. Upon analysis of the facts of this case, the majority of the Dalberg factors clearly weigh in favour of gaining the temporary injunction. So now they're going to look at all the elements. So they're going to break down the elements. So the first element is the relationship between the parties supports injunctive relief. The first factor involves the nature and background of the relationship between the parties, pre-existing the dispute giving rise to the request for relief. The factor is concerned with maintaining the status quo pending a decision on merits. Metro Sports Facility versus Minneapolis Twins Partnership, citing Pickering and Pasco Marketing Inc. Before this dispute, the parties had no relationship. Defendants had no professional or personal affiliation with the plaintiffs until she began her defamation campaign against them. Therefore, this factor favours plaintiffs. as the status quo supports no contact or no commentary between the parties. Second factor, the balance of harm favours the plaintiff. The second factor involves balancing the harm to the plaintiffs if the temporary injunction is not granted against the harm to the defendants if the court provides injunctive relief. See Dahlberg, at paragraphs 321 to 322. The Minnesota Court of Appeal has held that this is the most important factor in determining whether a temporary injunction should be issued. Eden versus Boston's. For this case, the potential harm to Plaintiff 7M gravely outweighs the harm to the defendants. As analysed above, 7M will suffer irreparable harm if the defendants continue their false and defamatory social media campaign. The severity of the defendants' actions, such as claims of human trafficking, waterboarding, and operating a cult, can cause irreparable harm to the plaintiff 7M's business and consumer goodwill, especially when such allegations are distributed on an online platform to hundreds of thousands of viewers. See Sajay versus Nagar. Now, remember, they're the two cases that they attach to the affidavit. At 38 to 39, holding that an individual would suffer irreparable harm when the opposing was using online platforms to accuse the proponent of SA, pedophilia, and Satanism. Plaintiff 7M is at risk of losing considerable business and customer goodwill to an extent that is impossible to quantify. Therefore, 7M will suffer irreparable harm if the temporary injunction is not granted. On the other hand, the harm to the defendants would be minimal at most. To bar a temporary injunction, the opponent is not held to an irreparable harm standard, but must show substantial harm. See Yago and Thompson, citing Vernon and Co. versus Minneapolis shareholders. So where it says citing, it means that this case here was used in this case here. Restraining one from coercively targeting one's business or publishing statements on the internet regarding the plaintiffs does not pose substantial risk of harm. See Ludgate. Upholding a temporary restraining order prohibiting a party from posting or broadcasting statements about the order's proponents. For this temporary injunction, plaintiffs simply ask the court enjoin the defendants from posting materials about the plaintiffs or their associates until this matter is adjudicated on its merits. There is no evidence that the defendants will suffer any harm as the result of the proposed temporary injunction. See Yeager 352. Reasoning that the opponents to a temporary injunction would suffer substantial harm when they would have been deprived of their sole source of livelihood, requiring the defendants to suspend her defamatory statements during this case is greatly outweighed by the irreparable harm that will be suffered by the plaintiffs. C. The plaintiffs can demonstrate the likelihood of success on merits. The Netz-Dahlberg factor requires the court to look at the likelihood that one party or the other will prevail on the merits. Paragraph 311. The court errs in granting temporary injunction relief if the proponent cannot show any likelihood of prevailing on merits. Haley versus Forsell, citing Metro Sports Facilities. However, if a plaintiff makes even a doubtful showing as the likelihood of prevailing on merits, a district court may consider issuing a temporary injunction, reasoning that the presence of some obstacles to a plaintiff's case is not enough to invalidate a district court's granting of a temporary injunction. In this case, plaintiffs had more than a doubtful chance of prevailing on merits. Plaintiffs have brought 9 counts against the defendants, including defamation, defamation per se, tortious interference of contract, commercial defamation, intentional infliction of emotional distress, deceptive trade practices, and intentional interference with prospective advantage. If plaintiffs can show that they have a likelihood of prevailing on the merits in merely one of these counts, then this factor outweighs the favour of granting the temporary injunction. A claim for defamation requires the plaintiff to prove 3 elements. The defamatory statements is communicated to someone other than the plaintiff. The statement is false, and the statement tends to harm the plaintiff's reputation and lower the plaintiff in the estimation of the community. See Bayer. And if the plaintiff is a public figure, there must also be a showing of actual malice, which means that they knew the statement to be false or uttered it in reckless disregard of its falsity. Rose versus Koch. In this matter, the defendants have published countless posts regarding the plaintiff 7M and its associates on her various social media platforms, which potentially have hundreds of thousands of followers. The defendant's posts, which include but not limited to outrageous accusations of human trafficking, waterboarding, and cult-like behaviour, are false. Defendant's posts have also damaged 7M's reputation and opinion in the talent community. Defendants have personally boasted about disparaging the plaintiff 7M's reputation and has disclosed that she played an active role in destroying any potential business relationship with the LA Clippers. Furthermore, defendants have failed to substantiate her claim against plaintiff 7M. To this date, defendants have failed to provide any corroborating evidence to prove her accusations against the plaintiff 7M are true. When confronted with her falsity, the defendants have simply backtracked and relabeled her statements of fact as opinions in Exhibit C. Defendants had knowledge of their falsity of at least some of her statements, at a minimum has displayed a reckless disregard for such falsity. Overall, the plaintiffs do have a likelihood of success on the merits for their defamation claim. Therefore, this factor outweighs the of granting a motion for a temporary injunction. Public policy supports the plaintiff's motion. The fourth factor is whether or not public policy supports the motion. So that's at paragraph 312 to 322. Society have a persuasive and strong interest in preventing and redressing attacks upon reputation. In Lukajovic versus Lorraine Journal Co., quoting Rose Blank versus Bayer, although temporary injunction arguably restricts defendants' freedom of speech, such freedom is not absolute. Individuals do not have a right to speak or publish without responsibility, whatever one may choose, or an unrestricted and unbridled license that gives them immunity for every possible use of language and prevents punishment for those who abuse this freedom. See Git Row versus New York. In other words, individuals do not have a right to say, or in this case post, whatever they like at the expense of others. Under these principles, a Minnesota District Court has held that public policy has favoured enjoining a litigant from making online content about the opposing party. See Sanjay at 40. In this case, public policy favours enjoining defendants' attacks against the plaintiff's reputation and business prospects. Defendants have used her platforms to render both heinous and baseless allegations that serve no interest to the public. Furthermore, it would not be an improper restriction on the defendant's First Amendment rights if she is restrained from publishing false and defamatory statements regarding the plaintiffs. Defendants should not be allowed to use her social media platforms to subject plaintiffs to immeasurable harm while we wait final adjudication on the matter. Therefore, the public policy factor weighs in favour of granting temporary injunction. E. The administrative burden on the court supports the plaintiff's motion. The final factor involves looking at the burden on the courts in the supervision and enforcement of the injunction relief. The plaintiff's requested temporary injunction would not require any performance or detailed surveillance by the court. The order would simply require monitoring the defendant's social media platforms, which could be conducted by the parties in this action. See Lad K at 12. Furthermore, the temporary injunction would only last until the adjudication of this action, minimising any impact on the court and parties. Therefore, granting the plaintiff's motion for temporary injunction would pose little to no administrative burden on the court. Conclusion overall, if the plaintiff's motion for temporary injunction is not granted, plaintiff 7M will suffer irreparable harm for which there is no adequate remedy at law. Furthermore, 4 of the 5 Dalberg factors weigh in favour of granting injunction relief, while remaining factor is neutral. Therefore, the totality of the Dalberg factors weighs in favour of granting the proposed temporary injunction, enjoining defendants from creating any social posts about plaintiff 7M or its associates. In the alternative, if the court does not grant the temporary injunction, plaintiffs respectfully request the court mandate the defendant include a disclaimer that she is currently being sued for defamation by plaintiff 7M with any picture or blocks of texts that she posts regarding 7M and associates. So, that's an interesting one. So they really want her to, so it's only temporary. It's only until the matter is determined by the court. So, until next year. So this is a motion for protective discovery order. So now we're going to go to the fact that she blasts, they're going to say that she blasts court documents all over the place. So the plaintiffs in this action seek a motion for protective order pursuant to Minnesota R Civil P 26 The underlying basis of this lawsuit is for defendants' continual dissemination of information about plaintiffs. Plaintiffs, in addition to their false and defamatory statements about the plaintiffs, have disseminated personal contact information about the plaintiffs and their associates, as well as disseminated court documents which are subject to a protective order in another lawsuit. As defendants have proven themselves to be unable to keep private and confidential information to themselves, plaintiffs respectfully request this court grant an order for protection precluding. So, in general, Minnesota Civic Procedure Rule 26.03 governs the protective orders and provides the following. A. In general, upon a motion by a party or by the person from whom discovery is sought, and for good cause shown, the court in which the action is pending, or alternatively, on matters relating to a deposition, the court in the district where the deposition is to be taken may make any order where justice requires to protect a party or person from annoyance, embarrassment, oppression, and undue burden or expense, including one or more of the following: that the discovery not be had. 2, that discovery may only be had only on the specified terms and conditions, including designation of a time or location or the allocation of expenses, disclosure of discovery. 3, that the discovery may be had only by method of discovery other than that selected by the party seeking discovery. That certain matters not be inquired into or the scope of discovery be limited. That discovery be conducted with no one present except persons designated by the court. That the deposition, after being sealed, be only opened by court order. That a trade secret or other confidential research, development, or commercial information not be disclosed or be disclosed in a designated way. Or that the parties simultaneously file specified documents or information enclosed in sealed envelopes to be directed by the court. Essentially, under Rule 26.03, the court may make any order which justice requires to protect a party or persons from annoyance, embarrassment, oppression, or undue burden or expense in the course of discovery and litigation upon showing good cause. The underlying cause of this action is for the defendant's statements to the public regarding the plaintiff. In their own social media posts, defendants have expressed their excitement for obtaining discovery against plaintiffs in this matter. Specifically, being served this lawsuit, defendants posted, "Let's go discovery, about to get real," fire emoji, Exhibit Q. Defendants have also exhibited a history of posting findings from discovery processes on their social media page. Specifically, defendants have posted excerpts from depositions on their Instagram page, Exhibit P. Some of these posts include sensitive and embarrassing information about the person being deposed. The defendants in this matter have served interrogatories and document requests upon plaintiffs, which include requests for private financial information, sensitive and private business information and medical records. Due to the sensitive nature of discovery being requested in this matter and the defendant's behaviour regarding discovery in this case and in other lawsuits, plaintiffs respectfully request that a protective order be entered into in this matter, allowing all discovery to be viewed by the defendants in the following manner. Or responses to interrogatories, documents requests, and requests for admission shall be viewed at counsel for plaintiff's office. So there's counsel for defendants shall only be the ones allowed to view discovery and take notes. Cell phones and other recording devices not be permitted in the room. All depositions and resulting transcripts shall be confidential, and the contents therefore shall not be disclosed to anyone other than the parties in this matter and their counsel. So it's very interesting that 7M's counsel or lawyers have really hit the nail on the head as far as her behaviour is concerned. Are they going to be successful? They might get one. They might get one of the motions. I think they've stated their case quite well, why they need it to be protected. Put in the stuff there about the Duggars and all that sort of stuff, and some of that graphic detail to show the extent it goes. But I'm interested to see what you think. So my as I said, I would have thought they would have come for a summary judgment. They would have gone, she hasn't filed yet, but they're prepared to give her until, in the amended dates, they're prepared to give her until the 9th of September to file a defence. And as I said at the time, if they've not filed anything of substance, so how do you know what documents you need until you've seen their defence or until you've seen what their arguments are going to be? You don't know. They've already said they're going to have 8 witnesses, so that's interesting. So, yeah. So it's definitely very, very interesting. Anyway, that is the latest with that. It's interesting, the differences. As I was working on my own defamation assignment in terms, serious harm quite often is actually implied. They don't need. So anyway, so watch this space and we'll see what happens. Please make sure you hit like and subscribe. Ring the bell so you get notified of when there's a new video, and I'll catch you again next time. Bye for now.